Hello students, today we are going to discuss very important topic of CPC, and this topic is the concept of res judicata. Section number 11 of CPC discuss about the doctrine of res judicata. The doctrine of res judicata is also known by the name of rule of conclusiveness of a judgment as to the points decided either of fact or of law or of fact and law in every subsequent suit between the same parties. Res judicata enacts that once a matter is finally decided by a competent court, I repeat, once a matter is finally decided by a competent court, then no party, plaintiff or defendant, can be permitted to reopen it in a subsequent litigation. In the absence of such a rule, there will be no end to litigation, and the parties would be put to constraint, trouble, harassment, and expenses. Basically, the doctrine of res judicata is based on three maxims. The first maxim is known as nemo debet bis vexari pro una et idem causa, which means that no one should be vexed twice for the same cause. Second maxim is interest republicia ut sit finis litem, which means that it is in the interest of the state that there should be an end to the litigation. And third maxim is res judicata pro veritate accipiutur, which means that a judicial decision must be accepted as correct. Section number 11 is read as under. What is the bare language of section number 11? Now let us discuss. Res judicata. No court shall try any suit or issue. I repeat, no court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit. Former suit means which has already been decided between the same parties or between the parties under whom they or any of them claim, litigating under the same title in a court competent to try such subsequent suit or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court. What are the various explanations of section number 11? Now let us discuss one by one. Explanation number 1 talks about the meaning of former suit. Former suit means the suit which has already been decided. It is not a matter when it has been instituted. Now let us discuss the bare language. The expression former suit shall denote a suit which has been decided prior to the suit in question, in which the question of res judicata arises, whether or not it was instituted prior thereto. Explanation number 2. For the purpose of this section, the competency of a court shall be determined irrespective of any provision as to the right of appeal from the decision of such court. It means that for the applicability of res judicata, while seeking the competency of a court, it has to be seen whether that court has the competence to decide such issue. It is not a matter whether any right of appeal from the decision of such court is given or not. Okay. And what explanation number 3 states? The matter above referred to must in the former suit have been alleged by one party and either denied or admitted expressly or impliedly by the other. Explanation number 4 states about the constructive res judicata. Any matter which might and ought to have been made a ground of defense or attack in such former suit shall be deemed to have been matter directly and substantially in issue in such suit. We will discuss explanation number 4 in detail in the next videos. Now let us explanation number 5 be read. Any relief claimed in the plaint which is not expressly granted by the decree by the court shall, for the purpose of this section number 11, be deemed to have been refused by the court. Explanation number 6 talks about res judicata in a representative suit. What it states, where persons litigate bona fide in respect of a public right or of a private right claimed in common for themselves and others, then all persons interested in such a right shall, for the purpose of this section, be deemed to claim under the person so litigating, and res judicata shall apply in their case as well. Now let us discuss about explanation number 7, which has been inserted by CPC Amendment Act 104 of 1976. This explanation brought the concept of res judicata for the execution of the decree. What it states, the provisions of this section shall apply to a proceeding for the execution of a decree, and references in this section number 11 to any suit, issue or former suit shall be construed as references respectively to a proceeding for the execution of the decree. Suit shall be replaced by the execution of the decree. Issue shall be replaced by question arising in such proceeding, and former suit shall be replaced by the name of formal proceeding for the execution of the decree. We will discuss it in detail in the next videos as well. Explanation number 8 states, an issue heard and finally decided by a court of limited jurisdiction. If the court has the limited jurisdiction over certain issues only, an issue heard and finally decided by a court of limited jurisdiction shall also operate as res judicata in a subsequent suit, notwithstanding that such court of limited jurisdiction was not competent to try such subsequent suit or the suit in which such issue has been subsequently raised. Now, I want to discuss very important note. When we see section number 1 subsection 3 clause B of the CPC, then we had read that provisions of CPC shall not be applicable in the state of Nagaland. But the principle of res judicata applies in Nagaland, though as per section 1 subsection 3 clause B of the code does not apply to Nagaland. Thank you. This is something about part number 1 on the concept of res judicata. Thank you.